must not be, because I keep asking him to unmute his phone because he's involved in some things that I know we're going to want to talk about, because a lot of guys are having reoccurring child support issues. But that's just the basis for my case. I'll break mine down a little bit more as we continue to move forward, because I wanted to show everybody a rule that I came across the other night. It's 1.420. And essentially, had I signed, which I did sign the stipulation of the parties, it only applies to the parties in the litigation here. There we go. And I found what I need you all to see. And just keep this in mind in case any of you ever have any litigation to deal with, or even have an attorney. Even if you have an attorney, never forget, that's your attorney, but it's your case. Are not required to be substituted as parties in an underlying lawsuit. And essentially, if you're not a party to the lawsuit, you can't be involved in the settlement. And you all can go read it. 1.420. You see this right here? It required the signature of all parties who have appeared in the action. Did anybody not see that? Or have a question about that? See that? And as we know in my case, against Chandra and Linda Tucker, the only ones who appeared in the action is Chandra and Linda Tucker. Even though they were represented by the attorney, they're the only ones, they're the only litigants other than myself in the action. And by the way, people, I think I talked to somebody about this. I really wish somebody would want to speak up. I know y'all got these bad connections. Mike, you out there, MJ?
Yeah, I'm here. No, I just finished this workout with these kids. I'm here though. I know I didn't want to be loud on the call and screaming and stuff.
Okay.
Yeah, you good.
Can you see that part right there? That's highlighted now?
Yeah.
Go ahead.
Will parties file a stipulation of voluntary dismissal, the trial court is divested of the case jurisdiction, which is the power of the court over a particular case that is within its subject matter jurisdictions.
So had he just filed this with stipulation was enough to get the money. They could have just, here's a stipulation and here's the $30,000. We're done. Had he filed it like he should have by rule, because nobody else is involved, Judge Peacock couldn't say anything else about the case ever anyway, because the case would have been voluntarily dismissed. What my argument is that he wanted to use the mediation to set up a byway to get everybody else out of a situation that he created when he and State Farm decided they would want to use a VA doctor to do the compulsory medical examination. And we all know we've already gone over 18 U.S.C. 208, which is a crime. And attorneys also are not supposed to be involved in crime. And if Mike Rowe did represent Shim, then what he would have been doing is, along with his client, participating in criminal activity. But that right there is where I wanted the folks to see, and I appreciate you reading that, Mike. So the bigger issue is that nobody else is a party to the case, and the only people that the court has jurisdiction over are people who appear before the court properly. And let me get into the cases. So. And also, when you all get a chance, make sure you read entire cases.